do you have the Senate, what the Senate sent back?
There you go. You can have this.
I apologize to everybody. I thought it was a different conference committee, and so I left. I thought it was the other one.
Good to see you, Senator.
Thank you. Good to see you.
And I will get you guys copies of what the Senate sent back.
Okay, all right.
And we are live further.
All right, excellent. So who chairs this? I can't remember if it's the House or the
Well,
Senate.
technically you chair it because it's a Senate bill.
Okay, I was trying to remember which way that went. It's been a little while, so I appreciate that. Thank you. So we received the Senate proposal amendment concurrence and further, and the Senate amendment, further amendment. I guess it's further amendment to the House amendment. And I guess just to cut right to it, I'd like to mention the three primary areas that we have issues with, and also a proposal. The main issue is with respect to what the knowingly standard has been changed to for the three different offenses, or the three different areas of drugs. I'm going to get into that a little bit more in depth. I'm going to turn that over to Joe Andriano in a moment to explain our rationale. But essentially, we looked at what courts have done with respect to that defense, the willful blindness or the ostrich defense, and we tried to match what that standard is to essentially match what the Second Circuit and also what the Supreme Court has done, and further, it's fairly close to what a proposal was from the the Department of State's attorneys. Actually, I think it's quite close as far as the appropriate standard. So the further thing is that the current knowingly standard, really, there isn't really any precedent for it. I mean, it's as far as what has come back and was in the original bill of the Senate. So that's one item. And again, I'll have Joe further explain that in a moment. The second is, we're fine with the extension to xylazine, but if we're going to the extension to xylazine, we think that we should take out the catch-all and just have it address really the fentanyl and the xylazine. So that's the second item. The third, I will say, first of all, before I get to the third, we're fine with the permissive inference and sending that to the Sentencing Commission. That's fine. But the third issue is with respect to the flash site and with respect to having the language that the state's attorney shall ask for a particular condition of release. And probably state's attorneys would be happy to hear me say this, but we think that gets into their discretion a little bit too much. It is another branch of government, and we think that they should have the discretion. I think as a suggestion or a flag that we can have that language in there, but it should be changed to a may instead of a shall have that particular condition of release. So those are the three items, and if I can, unless you have a question immediately, I'll just turn it over to Joe to explain a little bit further why we believe that the language we had for what the knowingly standard, the new knowingly standard, is the appropriate way to go.
Yeah, thank you all. So just to just to orient ourselves to the Senate's language here, which is that knowingly means actual knowledge that one or more preparations, compounds, etc., contain the regulated drug, fentanyl, for example, or consciously ignoring a substantial risk that one or more preparations, compounds, mixtures, or substances contain fentanyl. So what the House had changed that to was a two-part test. The defendant, one, subjectively believed that there is a high probability that one or more preparations, compounds, mixtures, or substances contain the regulated drug, and two, took deliberate actions to avoid learning that one or more preparations, mixtures contain the regulated drug. And so we base that on primarily for a couple of reasons. The first reason why we made the change is if you look at the case law involved in this, in particular a case called U.S. versus Rodriguez, which the state's attorneys had provided to us, it talks about the idea of substantial facts. And the standard that was put forth in the Senate language refers to substantial risk. And there's a difference between facts and risk. They're two different things, with risk being a broader category than facts. And the second reason why we propose a difference is that the Senate's language took off the element of taking actions to avoid the fact. And so these were the two things that we found in precedent. So just first of all, to talk a little bit about the Rodriguez case, which was a 1993 Second Circuit case. In that case, the Second Circuit said that a particular jury instruction permits jurors to infer knowledge only when persuaded beyond a reasonable doubt that the defendant was aware of a high probability of the fact in dispute and consciously avoided confirming that fact. So there's a two-step process that we have to go through there. And this was confirmed by the US Supreme Court in a case called Global Tech Appliances versus SEBSA. And in that case, the Supreme Court said, while the courts of appeals articulate the doctrine of willful blindness in slightly different ways, all appear to agree on two basic requirements. One, the defendant must subjectively believe that there is a high probability that a fact exists, and two, the defendant must take deliberate actions to avoid learning that fact. And this was also echoed in a memo that was sent, at least to House Judiciary. I didn't have the opportunity to see if it was also sent to Senate Judiciary by Department of State's Attorneys, Sheriffs. Which at least on for us, it was a memo dated 4/17/24 and was entitled S58 SAS Draft Discussion Notes. And this document had on the first page a footnote. And in that footnote, it says that the department are in support of an amendment to the definition of knowingly as contemplated in S58 to address situations where a defendant knowingly engages in selling, dispensing, or trafficking, but purposely avoids learning what drugs are being sold, dispensed, or trafficked, or claims to avoid knowing. And so they said, SAS has previously recommended the following language to accomplish the aims of US versus Rodriguez. Knowingly, this is the quote, knowingly shall include actual knowledge as well as situations in which an individual was aware there is a high probability of facts exist and deliberately and consciously avoided confirming the fact to deny knowledge if apprehended. An individual acts knowingly when the individual acts voluntarily and consciously and not inadvertently because of mistake or by accident. And so we feel that looking at the Rodriguez case, looking at the Global Tech case, and also looking at the recommendations of state's attorneys, that the language that we proposed over in the House version of the bill has this two-step test, the subjective belief, and then to take deliberate actions in order to avoid the ostrich defense that I think we're all worried about.
Any questions on that explanation, or just questions on
Well,
what our...
I have a number of questions about it. One is, I did not think that your language got the support of the state's attorneys. That's not what I heard. So I would like to hear from the state's attorneys particularly. I am concerned with the knowingly standard that you've put forth versus ours. There may be ground in the middle to make clear how you prove some of these factors in your bill. I just don't see how you prove that. And I don't have the language, unfortunately, I don't have the language in front of me. But I was concerned, I think the Senate Judiciary Committee was extremely concerned about the way that language came out. And I think our goal is the same, to make sure that if they're consciously aware, or should have been, that the fentanyl was in the drug, when 100% of the glassine bags have fentanyl in, that the Department of Public Safety has tested. Additionally, about 50 to 60% have xylazine. And our effort in the knowingly and adding the other drugs was, who knows what's next? I never thought that we'd see a day when people were using an animal tranquilizer as a drug to get high on. And frankly, I have no idea what's next. So that's the reason for the catch-all phrase. But we can negotiate all that, and that I think we're all on the same page here in that area of the bill. I think it's just how we get there. So I guess I need to. I would love to hear from the state's attorneys if they're in the room.
They are.
And I just wanted to say, I wasn't trying to represent that they agreed with our language. I was saying that the memo they provided had similar language to our language, even though it was not a perfect match.
Yeah,
And I'll defer to state's attorneys, yeah.
Whatever you all want.
Yeah, go ahead. Tim Leaders Dumont is here in the corner. I don't know if you can see him.
Yeah, so Tim Leaders Dumont, Department of State's Attorneys and Sheriffs, and the language that we had recommended, it's sort of interesting. It is a little bit of the mix of both of what you're trying to get at. So I think you're in the right room because it is a bit of a mix of both. We didn't believe that the word subjectively should be a part of the definition. Consciously ignoring, whether it's substantial risk or consciously ignoring facts, that's more what we believe is something that should be a part of the definition. And so that's sort of a melding of both. And in the memo that I had produced, it was our opinion that the Senate's version accomplished the aims of Rodriguez. And we did provide some language in the footnote, but also in a separate email to both chambers. Both chambers got the exact same stuff from me on this topic. So I'd say that the consciously ignoring piece, instead of subjectively, is something that we would advise. And the biggest piece, I think, where we have a variation is the subjectively, because that is something that may be a very high burden in a way where we may just end up reverting to the existing knowing standard, because overcoming subjectivity will be hard, but you know, we appreciate the efforts.
Is the language that is in the House definition, is that what comes from U.S. versus Rodriguez?
It's a variation on it. Rodriguez doesn't use the word subjectively, so I'm not speaking well subjectively. I believe, and I don't have the exact language in front of me right now, I'm looking at the side by side of the Senate and House, but I think they use the term to consciously ignore, if I recall correctly.
Okay, I just want to respond to that because I think it's important to note that the Rodriguez case was, there was an intervening case from the United States Supreme Court, which used the language again, this is the Global Tech case. All appear to agree on two basic requirements. The defendant must subjectively believe that there is a high probability that fact exists, and the defendant must take deliberate actions to avoid learning that fact. And so, the reason why the House language ultimately coalesced around that was the fact that there was the Supreme Court case that used this language.
And what was the Global Tech?
Yeah, I can give you a site on it. Give me just a second. I had it up because I was looking at it.
You have this in your
Oh, yes.
folders that
Sure.
I gave.
I do. Disregard that.
Okay.
Thank you.
I'll give you the site anyway, just for the record, in case you want to take a look. Global Tech is 563 US 754.
Thank you. And so the difference between trying to figure out the origins of this language, the difference, or rather the origin of our Senate definition, consciously ignoring a substantial risk.
I can tell you where that came from. That came from meetings almost 2 years ago with Jay Johnson, state's attorneys, my local police chief, and some others, and my state's attorney, who was really concerned about having the knowingly standard difficult to prove when there was death resulting, and everybody knew that the dealer did know that there was fentanyl in the drug. But to prove that he did know under our current standard wasn't possible. So that's the genesis of the bill. The original bill just dealt with the knowingly standard and the various drugs. And I think there was one other section. But the original bill was broadened because the Senate decided that they didn't want to put the criminal aspects, other sections into S209. They wanted to keep the Senate wanted to keep the S209 separate. That started out as S209 was designed to be the bill to deal with the crime. But then in conversations, we all agreed to put this into S58, all the other items. So quite frankly, it was really just about the knowingly standard as introduced.
So do you want to think about and work with state's attorney a little bit more to have something in between these two? Do we want to have Notter and Joe and state's attorney, or Notter and Joe and legislative council try to put their heads together to find that compromise language, Dick?
It would be fine with me if Nader and Joe worked with Ledge Council and not the states. I mean, obviously, I'm always happy to hear from the state's attorneys, particularly about any final compromise we come up with.
Right, because I think if we had state's attorney, we would have Defender General as well from our perspective. But yeah, I think they can with legislative council. I think that would be fine.
And I would only add that whatever we do unknowingly should be the same in any number of drugs that we come up with. I don't know what the next drug is.
Right, understood. So we'll have to ponder that a little bit more, but I think we first need to see if we can come to agreement on this knowingly standard. And I think that probably hashing it out in here is not the most effective use of our time, if that works for you, Notter and Joe, just to put the practicing attorneys' heads together with the legislative council. So as far as the other issue, the shall versus may, are you okay with moving that to may to?
As long as the language is in the bill, I mean, as long as the language becomes law, if the state's attorneys may request, that's fine. The point is, we were trying to get at the Decca Towers, the places all over the state that have become trap houses, and not impact the resident who's under a lease. We thought about that, but decided not to, rather than focusing on those drug dealers who move into those apartments or homes. And I think it's really important to have the language in there. I think the court may, and the states, and I haven't talked to the other conferees, but I think the most important thing is to have the language there to draw attention to the problem.
Right, appreciate that. So just one last thing, and before I think we probably can break now, is because we heard from state's attorney on the knowingly standard, I would like to hear from Rebecca Turner, who's here on the defender, because she had her hand up on when we were having that discussion. So if you could go ahead and introduce yourself to the record, just.
Thank you, Rebecca Turner, Defender General's Office, for the record. I just wanted to explain that Representative A said in terms of explaining that standard, the most current, the present law standard, the Second Circuit is the standard. If there is any trouble prosecuting with that Second Circuit standard, then it would be an issue of prosecutions in the federal circuit as well. But prosecutions of drug offenses are presumably going forward by federal prosecutors there. If there is an issue about state's attorneys having trouble meeting their abilities to meet under it. And the argument isn't to lower the legal standard. That is the law in the Second Circuit. That is the standard that federal prosecutors can do. I think possibly the question is whether or not we need better training or our issues on the prosecutor attorney side, not an issue of changing overall legal standard. That is again current law, the Second Circuit. So that's what I have to
Yeah,
share.
no, I appreciate that. Thank you, Rebecca. So,
Actually,
yeah,
very quick
yeah.
question. It seems like the word subjectively might be a bone of contention. Can you talk about the word subjectively in this context a little bit?
I think this is the United States Supreme Court language. As Representative Adriano pointed to the decision and the Second Circuit decision adopting it, postdates the case that the state's attorneys are referencing, and so this is the current law. And it is the standard that federal prosecutors are using to prosecute drug offenses. So I think that if there's any issues about how difficult it is for our local state prosecutors to advance these, I think that is an issue of perhaps training, but certainly not.
I'm gonna have to respond to that. She brings up training again, I have to respond to that. I'm sorry. I didn't say anything about Defender General's training, and that's not the point of discussion right now.
Right.
I'm sorry, I can't sit here and give a training comment again.
All right, that's, point taken. So yeah, if we can keep it to the, what the actual standard is, I'd appreciate that. So, you get your question answered? It's in the, it's in the case.
I'm just trying to figure out.
Studying those two cases
Yep.
might be the.
I think I'm trying to figure out what our goal is to compromise between these two definitions here. That's what
I could talk a little bit more about the Rodriguez case, because I think it's illustrative, or we could just talk about, I don't know, it's preference.
I think you two going away and looking closely at the language of the two cases and whatever other precedent there is with Michelle, probably the best approach.
You two go away. I like that. I didn't expect that from you, Martin.
Sending most of the lawyers out of the room, except that means I have to go too. So, all right, so hopefully we can hear back from them and maybe even informally figure out where we are and meet first thing tomorrow morning to wrap this up, or later
Well, we're
today.
already meeting on another conference committee first thing tomorrow morning.
Okay. So maybe, I mean, if we can do this informally, since we have now met, and try to have Michelle actually draft a conference committee report that, based on whatever these fine legal minds can come up with, and see if we can all agree with that. So, I'll work through Ben to be in touch with you, Senator Sears.
Yeah, I'm, obviously free anytime we're not on the floor. So it really depends on our floor time. I would suggest that we try to meet, giving Ben and, Nader and Joe and Michelle time to work on it. I would suggest we try to meet around noontime. We should be off the floor by then.
Okay, unless we can still meet this evening. I don't know how late you guys are gonna be going, but yeah, we'll be in touch.
I expect we're gonna be going late tonight.
All right, yeah, I think here too.
I don't think there's enough time tonight to do it. If Ben Dorbach, how much time do we need tomorrow morning in Senate Judiciary?
Okay, so I was gonna say probably 5 minutes to go over the changes to, the climate super fund, because that's a really minimal changes, it seemed like. And then we need to finish up with Ben Novogoski. That'll probably take about 20 minutes. And then, I believe you guys are probably gonna want to review some quick changes to 780, the judicial nominee.
So I'm gonna talk to Senator Sears offline as
Okay.
soon as we go off, if he has a few more minutes.
Sounds good. So I would say
About a couple issues.
about tomorrow morning would be probably 30 to 45 minutes. We would need to meet.
Okay, so we wouldn't have
Okay.
time. We
Okay.
wouldn't have time because we got another conference scheduled at 8:30. So,
All right, well, we'll be available whenever there happens to be a break from the floor. We'll come off the floor if necessary, so.
okay. Well, we may want to too, so.
Did they send that back?
Right.
I wish we had an excuse to get off the floor this morning during that debate. on the elections bill. I mean, excuse me, the ethics bill.
Ethics.
Ethics bill, okay.
So, yeah, we'll be in touch. Do you want to just stay right here, Martin, and
Yeah, I'll
talk?
stay